Okay, the attendance is on. Okay, I think we're ready to roll. Oh, closed captions, one more thing. I keep having to do more things for class starts. Okay. And the captions are now on. Okay, now we can start. All right, good morning, everyone. I hope everyone had a good night's sleep. I know I did. Any questions before we get started? Anything else on your minds? It was a late night. All right. Let's get started. I'd like to, at the outset, as best as I can, give an overview of the various 14th Amendment cases we've covered. Right? Basically, the second half of the semester is all about the 14th Amendment. And I want to try to summarize all these as best as I can. I don't think I can do it well, but I'll try. If you look at page 176 of the 100 Cases book, it gives a decent summary, but let me try to bring it all together if I can. We have 3 or 4 major provisions of the 14th Amendment we've covered, depending how you count. We have the Privileges or Immunities Clause. And we have 3 cases for that provision. We have Slaughterhouse and Bradwell. Those cases held that the Privileges or Immunities Clause does not protect an unenumerated right to contract, to pursue a common vocation. And then we have Cruikshank, which held that the 14th Amendment's Privileges or Immunities Clause does not protect a right protected by the Bill of Rights, the First and Second Amendments. Next, we have the Due Process Clause and the Equal Protection Clause of the 14th Amendment. And we have 2 early cases on them, Yickwo and Plessy. Yickwo held that certain arbitrary laws that deprive people of a license to run a business is unconstitutional. In this case, the rationale was completely random. There was no reason. And in fact, the reason was to target Chinese Americans. But in Plessy, the court sort of went the other direction and held that the government can mandate separate train accommodations even when the private businesses may not want it. This was a separate equal doctrine. And the remaining part of the 14th Amendment is really Section 5, which is the enforcement power. And we had 2 cases which discussed Section 5. The first is Strouder versus West Virginia. And Strouder upheld a removal provision that allowed a black man to remove his case when he had an all-white jury, when there was no black people allowed onto the jury. The second case was the Civil Rights case, which considered the Civil Rights Act of 1875. This was a statute that made it a crime to engage in discrimination in certain places of public accommodation. The court declared that statute unconstitutional and said that the 14th Amendment only regulates state action. It does not regulate private action, right? Private action is beyond the scope of the amendment. Okay? Those are all the cases from the 1800s. All right? We move next to cases from the 20th century. And so far, all of our cases from the 20th century concern the Due Process Clause. Until today, we've actually not had any equal protection cases from the 20th century. And the simple reason is Plessy. under the separate but equal doctrine, the Equal Protection Clause was basically a dead letter. But even with Plessy, you still had some juice for the Due Process Clause, right? You had PRI, privileges, immunity is dead. You have equal protection is dead. You have Section 5 is dead. But there was still some space for the for the Due Process Clause. And during the early 20th century, the Due Process Clause began to expand the scope of judicial review. So the first case from this era, of course, is Lochner, our favorite case, our favorite bakery in upstate New York. And Lochner began with a discussion of a right of economic liberty, or right of contract. And the court explained that if the government wants to burden this right of contract, the government has the burden to show that the policy is reasonable, the policy is necessary. This so-called presumption of liberty was used in a number of early cases. In Muller v. Oregon, the court applied the same framework but said that the government did defend its law. They had enough evidence to show that women were inferior and needed to have a maximum hour law to protect them. And then we have Buchanan versus Warley, which found that a segregation ordinance, which limited the sale of property to people, was actually a violation of due process. Buchanan was not an equal protection case. It couldn't have been, because under Plessy, the law was just fine. And the peak of the Lochner era, the high water mark, if you will, was Atkins versus Children's Hospital of D.C. And Atkins was this decision that held that Congress could not impose a minimum wage for women. Right? That women had achieved a political and social equality, and that their liberty of contract prevented this sort of restriction. Now, all four of these cases applied this sort of presumption of liberty in economic context. But then we study three cases that might be called personal liberty cases. We have Meyer against Nebraska, we have Pierce v. Society of Sisters, and we have Buck v. Bell. Right? Meyer and Pierce were personal liberty cases with an economic flavor. You had a teacher working, and you had a school teaching. I don't know. And I think what these cases show is that there was not a sharp line between economic and personal cases. They were very flimsy, right? The progressive era, the 1920s, didn't really distinguish between these two. But then we get to Buck v. Bell, which is a sort of anti-canon case, if you will, that's somehow still good law, where the court upheld the forcible sterilization because they said the state had a really compelling interest to, promote eugenics and promote the public good, and the burden on Carrie Buck was justified. Okay, so far we are, we're in cases where they're applying the sort of presumption of liberty. Buck is a bit of an outlier, but they're applying the same framework. Then we come to West Coast Hotel, which shifted the court's approach, right? It wasn't only West Coast, but West Coast made it very clear that now the court would not apply this presumption of liberty anymore. They'd apply more of a presumption of constitutionality, where the court presume that these sorts of economic regulations are valid unless, the challenger, the plaintiff, can put forward evidence showing that the law was unreasonable. And in West Coast Hotel, the court found that the minimum wage law for women was valid, it was reasonable. Okay. Then 1 year later, we have United States against Carolene Products, right, with its famous footnote 4. Carolene Products tweaked this presumption of constitutionality in an important way where it said, we will generally apply a presumption of constitutionality unless you fit in certain categories. And it wasn't actually a holding, to be very clear. It wasn't a ruling. It was sort of just this dicta. It said, well, maybe we won't apply it here, and maybe we won't apply it there, and maybe we'll see here. But if a law burdens a specific provision of the Bill of Rights, you generally give it heightened scrutiny. That's the first 10 amendments. If a law distorts the political process by which people are appointed, you might give that law heightened review. If a law targets religious, national, or so-called discrete and insular minorities, it would get a form of heightened review. And if you notice, footnote 4 mentioned racial minorities, which was very significant because at the time, Plessy was still the law of the land, right? That was the law. Can you reconcile footnote 4 with the Plessy doctrine? So you're already seeing the court starting to, cast some doubt on its equal protection clause cases in the late 1800s. But they made no effort to even hint that those were wrong. They didn't say it outright, but this tension begins to form. Right? But still, Carolene Products is a test of deference. But then we get to Williams v. Optical, which says courts should not be in the business of second-guessing the wisdom of the legislature. Right? So long as there's some rational basis on which the government might have acted. What might be called a conceivable basis, right? Is there some conceivable basis on which the government might have acted? Then the action is valid. To be frank, Carolene Products is intentionally optical, right? Because why do you have these three arbitrary carve-outs? So what if a law targets minorities, right? So what? If the government has some rational basis, why can't they do it, right? Lee Optical is a measure of deference. It said that the elected branches should have the latitude to do as they wish. Okay? Everyone with me? Okay, so Williamson v. Lee Optical was decided in 1955. Our first case, Brown, was decided the year before, in 1954. So we have to sort of situate Brown in the time in which it was decided. So you had this very strong movement among the New Deal justices about deference, deferring to the elected branches, especially when there's no clear constitutional command. And then you have Brown, which seems to be the opposite, to not be deferential, to be second-guessing, right? And we have to figure out, how do we square Brown with this post-New Deal approach to judicial deference? And I think what you begin to realize is that the court was never committed to this idea of deference across the board. They were favoring deference in certain spheres for economic regulations. What we'll find is that in other spheres, racial issues, privacy issues, this deference is thrown out the window. So all along, the opposition to Lochner was not judges rigorously reviewing laws. The opposition was judges reviewing economic laws in a specific category. Right? Other types of laws were subject to this sort of heightened review, but not economic statutes. All right. All right. I think I did decent review. Questions so far? Yes, Erin, go ahead, please.
I don't think I have this written down on my notes, but is Buchanan still good law or is it bad law?
Buchanan is good law, but it's usually described as an equal protection case. Most courts won't acknowledge that it was a substantive due process case because that sort of defies the narrative, right? Because then it looks like a Lochner style case. People won't admit that, but Buchanan is considered good law for a lot of reasons. I mean, it's also good law because now that the Plessy case was overruled, you don't even need due process, but at the time it was a due process case. Yeah, most ConLaw case books don't even have Buchanan in there. I think it's an important case. I asked Randy to add it, but most people sort of forgotten about it. It just doesn't really get much attention anymore. Sorry, my new screen bar is noisy. I apologize. I once gave a talk, I think it was at Chicago, and they had, this is when we actually had in-person events, right? And they gave everyone a sandwich with this paper wrapping. And the first minute of my talk was just this incessant crinkling. I couldn't stand it. So I said, all right, everyone, take your sandwich out of your wrapper now. Go. And it was like this cacophony of sandwiches. And it was over. It was quiet for the rest of the event. So I'm guilty of my own sin of making my own wrappers. Wrappers are noisy. Okay. Other questions? No? Is that a question, Moses? I so you popped up for a second.
I did, and then decided to withdraw it. So I was going to basically ask, then how are we to look at Buchanan today? That's all I was going to ask. But
I think the way you look at Buchanan today, it's a good case under the Equal Protection Clause. I don't know that it's due process analysis that stands to this day. I think it's how you probably have to look at it. Make sense?
Okay, thanks.
Yeah, my pleasure. Okay. So let's go into cases today. 4 very important cases, which you probably are familiar with before you even came to law school. Most people, you pull a random person in the street, you ask them to name a Supreme Court case. Brown versus Board is probably one of them. Roe v. Wade's another one. Maybe Bush v. Gore, although that's sort of fading. We'll see if we have Biden v. Trump coming up soon, right? There's certain cases that resonate very well and are just well known. And Brown is one of them. Now, the story of Brown is a fascinating story. There have been many, many books written on it. So I'm going to do my best to try to summarize it, but there's a lot of really good and important history here. Throughout the early 20th century, groups like the NAACP developed a very coordinated legal strategy. And their goal ultimately was to reverse Plessy. That was the sort of end game, right? That's what they wanted to achieve. But they recognized that it wasn't feasible to do it right away. There just wasn't going to be support for it. I mean, even in the 1930s, federal anti-lynching bills are being killed in Congress. They couldn't even pass an anti-lynching bill, right, in the 30s. During this period in the South, to become a member of Congress, you had to be a member of the Klan, right? That was your social calling, right? Senator Hugo Black of Alabama, who became a justice, was a former Klansman, right? That was you needed to have that in order to have the political support in a state. So they recognized that Plessy was not going to be overturned overnight. And at the time, segregation in schools was pervasive. And it wasn't just in what you might consider southern states. States like Delaware had it as well. And there were smaller pockets throughout the North that had segregated schools as well. It was not just in the former Confederate states. So initially, the strategy of the NAACP was more modest. They said, look, we have this thing that says separate but equal. Let's try to show that these schools are not actually equal, right? That the schools for the black students are inferior. They're not given the same funding. They don't have the same number of teachers. Facilities are worse. These sorts of measures. And these cases were actually successful because saying, look to the court, look, we're not overruling Plessy, but give us the same amount of funding. And if the states want to say Plessy's right, then they basically say, okay, fine, we'll give more funding. So that was like this sort of intermediary approach. The next phase of the litigation focused on higher education, colleges and grad schools. And these were considered easier lifts because by the time someone goes to college, they're not living with their parents anymore, or they're sort of on their own. It wasn't considered quite as controversial. So one of the most famous cases which affects us here in Houston is a case called Sweat versus Painter, Painter, Sweat versus Painter. UT at Austin, University of Texas at Austin, had prohibited black students from being admitted. At the time, then, there was no public law school in the state that would admit black students. South Texas always did. This is actually one of our, we have, if you ever go to the building anymore, we have this little timeline on the right by the elevators. You've seen it, and we had black students for a fairly long time. So there was a private law school that did, but there was no public law school. So Texas was sued, saying, "Look, you can't have this where you only have a white law school. There's no equal program. We can't go anywhere, right? Give us a separate program." So what did Texas do? Did they integrate UT? No, of course not. They just made a separate law school at TSU in Houston, Texas Southern, which was a historically black college and university. But this went to the Supreme Court of the United States, and it turned out that the TSU school was not actually equal, that the funding was not the same, the facilities were not the same, so they're in a violation of separate but equal. There also were violations, I think, in Oklahoma and a few other states of different graduate programs. And the justices seemed to be willing to go to grad schools and colleges because it wasn't quite as controversial. But the NAACP recognized that K through 12 was the key. And I think Justice Marshall, I'm paraphrasing, but he basically said that there was this fear among white people that, if their kids were allowed to go to school with other black kids, then they would see it's not so bad. And the resistance to integrating K through 12 was this thinking that, oh man, if our kids are allowed to be around their kids, then, they'll realize that maybe we're not supposed to have this. This is bad, the segregation, right? So the fighting was far more vicious with the K through 12 market. That was the holy grail of the litigation. So by the time you get to the 50s, the NAACP realizes that the time to challenge Brown was now. Challenge Plessy was now. That was like the window. And they challenged the school segregation laws in four states in one district, right? So you challenged Kansas, South Carolina, Virginia, Delaware. And also the District of Columbia. We'll get to the DC case a little bit later in class. The case was initially argued in 1952. And you might think, oh yeah, this is a slam dunk, right, Josh? 9-0. Not so fast. They couldn't reach a majority opinion that was unanimous. And there was a very strong fear that if this decision had a dissent, it would be really bad. Because the southern states could look to the dissent and say, the dissent's correct, not the majority. So there's a very strong desire to get a cohesive majority, but they couldn't agree on a rationale. And this is a common theme. It's hard for the court to become unanimous when there's such different people. And at the time, Chief Justice Vinson, to be frank, was not the best leader. He's not well known. People don't know who he is. His most famous opinion is probably his Youngstown dissent, right? It's rare when the Chief Justice is a dissent in a very big case. But Chief Justice Vinson was in office, and he couldn't quite put things together. But then things changed. Vincent died in September 1953, right before the court's term begins in October. And then President Eisenhower made probably his most significant decision since the war, probably of all time. He put Earl Warren, the California governor, on the Supreme Court. Why did he pick Earl Warren? Because there's some evidence Warren wanted to run for president and challenged Eisenhower for the nomination, right? This is amazing things you think about, right? Ike probably put Earl Warren in the court, right, to keep him out of the political landscape. But Warren would become probably the most significant progressive Chief Justice ever. A Republican nominee, to be sure, but became quite liberal. And Warren was able to bring his considerable political skills to bear. And in this case, the re-argument of the case proved pivotal. And Warren was able to twist arms and write a narrow opinion which all 9 justices were able to join. And that proved momentous to get a unanimous decision in a school desegregation case. All right, I just compressed like 40 years of history in a few minutes. I know I skipped over a lot of stuff. Are there any questions on that history? Okay. All right, my friends. Who's next?
That's me, Professor.
Okay, Gracia, thank you. All right, so let's start with Chief Justice Warren's analysis, right? What role does he see that history plays in this case?
Well, he goes back to the time when the 14th Amendment was adopted, but he doesn't seem to be too persuaded by that. He actually says that the facts during that time were inconclusive. I guess the background during that time was inconclusive in helping the court in Brown.
What does that mean, inconclusive?
I kind of took it as it's not really helping the court today in deciding.
Well,
Brown.
It's not helping them decide it the way they want.
Right.
So let me ask the question again. Why couldn't the answer be, well, the history shows that school segregation was okay, and that's the answer? Why couldn't that be the answer?
I think that could not be the answer because I think it would just be an unpopular decision.
Are courts supposed to make decisions based on what's popular? Is that what we're here for? Is the entire semester is like what's popular? Is that what our class is?
No, that's definitely not usually the case. But I think that here, I think that they wanted to get this right, and I think like how you mentioned.
Well, hold on. I'm sorry. I just want to pause you. Get this right. What do you mean get this right? What does it mean to get a decision right?
I think that that segregating K through 12 schools, if that were the holding, I'm trying to see how I can say this.
I know. I'm putting you a hard question. I know I am.
Basically, if they said that was the holding, I think it would just further divide the country.
So the point of the court's goal is to unite the country. Is that the Constitution gives the court the power to do?
No, it doesn't.
I'm sorry, Grace. You were just next in the draw. I'm sorry you get this question. You're doing very well, I think. Well, why couldn't they just say, here, I'll leave you alone. You're good. I've tortured you enough. Colin, I think you're next. You did well. Thank you, Gracia. Colin, you here?
Yes, sir. Good morning.
Okay, I'll give you the same question I gave to Gracia a moment ago. Why couldn't they just say, you know what? The history shows that the framers of the 14th Amendment were okay with segregated schools, and that's it. That's Plessy's okay. We're okay with that. That's the rule. If people 20 years after the 14th Amendment thought this was a rule, how are we 100 years later supposed to make a better decision?
I mean, I think they were looking to extrinsic evidence that showed like the social climate had changed.
Look, you're right, but why couldn't they just stop with history and say, okay, we're done. That's it. Sorry, Mr. Brown. Sorry, Brown family, your daughter's to go to the other school.
Because history would have just perpetuated that injustice.
Yeah, but why is it injustice if that's what the 14th Amendment means?
Because it was antithetical to maybe their perception of what the 14th Amendment should be.
Well, what controls what the people think today, what the text meant 120 years ago, whenever it was?
Depends on the justice, I guess.
Ashley, you here? Ashley?
Hi, yeah, I'm here.
I'll give you the same question. Why do the courts get to substitute their own perceptions for those of the people who framed the document? What gives them that license?
I think if you believe that the Constitution is a living document, like Chief Justice Marshall said, then you can get to do that.
Did he say that?
I thought he said that in one of the first cases he read, but I'm apparently wrong.
So I think I know the line you're thinking of. He said, we must never forget it's a constitutional propounding that was intended to endure for the ages.
Yeah.
He was talking about Congress, actually, not the courts. That Congress could be able to develop new ways of developing necessary and proper laws. He wasn't talking about the courts. But I'll take your point, right? I think your point's a little different. Your point is, forget John Marshall for a minute, right? I always forget. Was it forgetting Sarah Marshall? Forget John Marshall for a minute, right? That's good. How can a court say, you know what? We understand the 14th Amendment, the framers intended X, and we just think they're wrong. What gives 5 or 9 justices in the 1950s the power to just set aside the document they're actually interpreting and say, you know what, we don't really care what they mean. We're going to go our own direction.
Well, I think that's kind of, like what you just said, that would be their interpretation of the document.
Right, but why does the modern interpretation get to trump the interpretation of those who framed it?
I kind of just think because we live in, that was the time, and it should be growing with the times in order to actually do what the framers set out for the Constitution to do, or the framers of the 14th to actually. Not that they could foresee desegregation as the issue, but if they choose to not view African Americans as like the second society they were at the time, then I think this is a natural evolution of that in the modern day that the justices were trying to achieve, which they decided to ignore what they wanted in order to achieve it.
Yeah, at least they're honest about it, right? Yeah. All right, very good, Ashley. I appreciate your answer. I think all 4 of you I just called on gave me very, very good insights. I don't think there's a good answer to my question, which is why I'm sort of smiling and smirking. I don't like watching students struggle and twist in the wind, but I do it on occasion to try to illustrate a point. The court here is candid, right? They're honest. They're not trying to hide the ball, as some judges, I think, do, right? Chief Justice Warren says, look, we asked for briefing on this question about whether those who framed the 14th Amendment would have intended to prohibit school segregation. Right? Did those who frame and ratify this amendment expect segregated schools to be unconstitutional? And he basically says it's inconclusive, right? The history does not give a clear answer. And then the court says, it doesn't really matter, though, what they thought. He says, we cannot turn the clock back to 1868. That was the year the 14th Amendment was ratified. We cannot turn the clock back to 1896, which was the year Plessy was decided. Instead, we have to consider public education in light of its full development and its present place, that is, the place in 1955, or 54, I'm sorry, in American life. Right? This is probably one of the most famous repudiations of originalism ever written. And the argument goes like this. Brown has to be correct, right? Brown can't be wrong. And any theory that does not lead to Brown must be wrong. Therefore, originalism must be wrong. And it's just, generations of law students read the same case that you guys just read. And they read the same passage. Oh, well, how can we be originalists if originalism is inconsistent with Brown? You need a theory of constitutional law to support Brown. Now, I never bought that argument. Maybe the argument is, the framers of the 14th Amendment were imperfect. They didn't anticipate all the problems. Maybe they just weren't thinking of school segregation. Schools were just not very common. There were not public schools very often in the 1800s. It just wasn't a common thing. Maybe we need to pass a new amendment to expand equality. Maybe the states need to pass statutes. Maybe there needs to be different types of legislation to do this, right? Why do we think the court is the only branch to accomplish it? And if you don't like that answer, look at the Cooper versus Aaron case. We'll study it later. The court issued its ruling, which was ignored, right? Entire districts in this country shut down their schools rather than integrate. So don't think for a minute that Brown was his panacea. It was the elected branches. It was the president sending in National Guards and paratroopers to Arkansas that opened up school doors. It wasn't the Supreme Court, indirectly at least. So I've never accepted the argument that a theory has to be wrong because it leads to a bad result, which is why I gave someone this difficulty. What's the right result? But here there's some evidence, and I think it's actually decent evidence, that Chief Justice Warren was wrong. There were strong efforts in the wake of the 14th Amendment to actually eliminate school segregation for reasons that are complicated, but I can go to later if you like. They were not successful. But when we're looking at the intent of those who framed the document, we don't need to only look at what statutes passed, but how are these terms understood? I think you can make a credible case, not lock solid, but a credible case that school desegregation was inconsistent with the 14th Amendment. Right? The fact that D.C. had segregated schools is some evidence, and there's some evidence coming the other way. So probably the better answer is the court in the 1950s didn't have all the evidence at its disposal. They were looking only at 1868, and they didn't look at the sort of enforcement acts that were passed in the wake of that period. I don't think it would have mattered. I think the court was going to reach its ruling regardless of what the history showed. They made that very clear. But don't think that they got it perfect, because there's some other history that they just had not considered. All right? So question the first part of the Brown case. It's a very famous passage, and I swear every judicial nominee who even hints at originalism is asked, well, what about Brown? And all the same answer. Brown's consistent with the original. Now they all say it's the same standard answer. It's a stock answer. But they all say, yes, Brown was correctly decided. Don't ask them if Roe v. Wade was correctly decided. They will not answer that question. They refuse to. They'll tell you that Brown was correctly decided because everyone has to like Brown, right? The better question is to ask a nominee, was Bolling v. Sharpe correctly decided? That's a much better question. They haven't gotten it yet because no one knows what Bolling v. Sharpe is. You know what it is. You read it for class today. That's a much better question. Was Bolling correctly decided? That is a much tougher road for originalists to argue. Bolling. You can do it. Randy does it. Not as persuasive as Randy is, but you can do it. All right. Questions so far?
Professor, this is Moses again. Can you summarize what you just said about originalism? Because I missed something along the way. Can you give a one-sentence summary that crystallizes what you're trying to say? I'm struggling here.
One sentence. I'll try. It might be two sentences.
Okay.
Brown is considered like a canon case, right? That everyone thinks has correctly decided, right? Brown has to be correct because I think Actually, it's the just result, or people frame it different ways. Right? That has to be the right result. Okay, so that's sentence number 1. Sentence number 2. I'm going to do 3. Sentence number 2 is any theory of constitutional law that does not lead to Brown, right? Any theory of constitutional law that's inconsistent with Brown is a flawed theory, right? You can't adopt a theory of constitutional law unless it supports the outcome in Brown. That's sentence number 2. Sentence number 3. Chief Justice Warren said originalism can't support school desegregation. Therefore, originalism is just inconclusive. It's irrelevant. We don't need it. We can't use it. How's that? I did 3 sentences instead of 1. I'm sorry.
No, actually, I appreciate the 3 sentences the way that you phrased it. It makes it clear. Of course, I'm hanging my head on the word inconclusive. Because I think I'm hearing you say, or the discussion say, but you may not be saying it, but I'm hearing it in my head, that inconclusive means conclusion, resolution. And I hear inconclusive, the debate in my head is inconclusive means it's all over the map. And you can go and, you can find something to support everything at one time.
Oh, I see what you're saying. Right. I think the way that modern debate uses inconclusive is it can't support Brown, right? It maybe there's like some shreds of evidence to support school desegregation, but it can't justify the outcome of the case, right? It can't justify a court intervening and saying that this school law is invalid, right? I think the word inconclusive, I think Warren chose very deliberately, to be honest, Moses. I don't think he actually meant inconclusive the way you're saying. I think what he meant is it's not getting us where we want to go, so we're not going to use it. I think he was sort of just being kind of like dancing around it. Because the history he was looking at, when you look at the briefs, it was not good for Kansas and Delaware and the other states. It really wasn't. There's some other history he didn't look at. But if you look at the evidence he was studying, it wasn't good for the schools. It suggested that the history was, I'm sorry, saying this wrong. The history wasn't good for the plaintiffs, for the Brown family, right? It supported the states much more. I'm sorry, I flipped it in my head.
No, and you're correct in that sense. I don't want to admit that, but yeah, you're correct in that sense. Even when we look at what happened here in Houston about that time period, there's actually, there was an investment by the school district in black schools around the 1950s. Mm-hmm. So in many ways, actually, the court was actually correct in that sense. I'm thinking back in my head to Dred Scott, where Taney completely ignores a segment of history and cherry picks one side of it, and he didn't use the word inconclusive. He said, no, I mean, it's right here, slaves are not citizens. So that's the wrestling in my head that's going on, is I'm contrasting what you're saying with Brown, and then it's like, well, here's Dred Scott that took a whole different approach.
Would you be more settled if Chief Justice Warren said there's some evidence to show that people oppose school desegregation, but it's not enough for us to base a decision on, right? There's some evidence, but it's we can't rely entirely on it. We have to do some other modern social science, work. Would that be in your mind a stronger opinion? So no, not cherry picking. We're saying, look, here we're laying out all the history, and instead of saying conclusive, look, it's mixed, right? There's some evidence going left and some evidence going right. And it's just not enough to decide this case.
See, that's how I thought he did. That's how I read Brown. The latter piece of what you just said. That's how I read it. Oh. That there's just not enough. I mean, there's a whole lot, but it's so damn messy. We need to choose something else.
Yeah, I think he was a little bit. Maybe it's a Rorschach test, right? I think you can maybe read it both ways, but I if you look at the sort of briefing that they had, it wasn't very good for the Brown family, right? The history that was put forward was more towards the states.
No, yeah. In that part again, and then you listen to the personal story of the Brown family, you realize it's even more complicated in Kansas than obviously what we all make it out to be. So.
And also keep in mind that the key fact he mentioned was the schools are segregated in D.C. And I think that's a really important fact. It's like, the very Congress that passed the Reconstruction Amendments left in place segregated schools in the nation's capital. I think that's like the one evidence he actually talks about in any depth. I think in his mind, that's like that's it, right? There might be some other cherry picking evidence, but this is like evidence that directly bears on this question. Yeah, but thank you. Very good questions. It's one of the challenges of the Brown case is it's short, right? I think you're all probably like, wow, this is not a short decision. I didn't edit this down. I think I have almost the entire case, maybe edit a little bit here and there, but it's a short opinion, right? It's short. And Chief Justice Warren said as little as humanly possible to get a narrow 9-0 opinion, right? I just want to explain how this works, right? When you're writing a majority opinion, you have to keep everyone on board. So every sentence has to be signed on by every justice. And let's say you have one sentence here that makes Justice A happy, it makes Justice B angry. And he's like, you know what? I'm going to dissent because I don't like sentence B. Okay, so you delete the sentence and then you piss off Justice A. He's like, oh, I'm not joining that opinion. So Warren's task was to write something that was so narrow, so specific, so, I don't want to say bland, but I'm going to say generic, right? So as not to alienate any of his colleagues. So this discussion of history, I think Moses is sort of picking up on this, I think, quite well. He was very not direct with how he described it. He sort of talked around it so as to avoid taking a hard issue. Because what he didn't want to do was come out and say the entire foundation of Plessy is wrong, right? He didn't want to undermine Plessy in its entirety because he didn't have the votes for that. He didn't want to say that the 14th Amendment actually has evidence supporting equality of the races. He couldn't say that because that would cast a lot of other precedents in doubt. So he had to say things like inconclusive, which again, it's a word that I think has multiple meanings. It's susceptible to multiple ways of reading it. It can mean, I think Moses said, all over the place, right? Evidence is all over the place. Or it can mean it's just not going to help us decide the case, right? And I think you could read it either way. I think it was quite deliberate. He was a very skilled politician, Earl Warren was. He knew how to write things carefully. All right. Let's move on from the historical question. I think next up is Lauren. I think you're next. You here, Lauren?
Yeah. Hello, can you hear me?
Yes, thank you, Lauren. So, Lauren, we let's put the history aside for the minute. We've gone through the history stuff for a bit. And next, Chief Justice Warren discusses the basis of why school segregation is unconstitutional. And I just want you to spell this out for me if you can with some precision. Why does school segregation violate the 14th Amendment? That's my question for you.
Because the schools were not actually equal, even though they were separate, and because because they weren't actually equal, and because education is like a fundamental part of citizenship. And
whoa, hold on. Okay, so the first part I get, schools are not equal, right? So if the schools are not equal, isn't that consistent with Plessy that, okay, then you have to equalize the schools and then you just, you give them more funding and, you give them more money. Isn't that what Plessy says? If they're not equal, make them equal.
Yes, but then they went on to the racial inferiority.
Is the problem the equality or the separateness? I want to just pin on that point for a minute.
It's the problem is the effect that the separateness has on equality.
Oh, okay, good. Now you're on the right track. Okay. So why is separate, having the forget the separate equal, just why is the separate schools problematic under the 14th Amendment, according to the court?
Because keeping them separate deprived Black students of equal protection.
Well, that's true, but that's the equal, right? That's saying they're not getting equal education. But why is segregation, why is separation itself unconstitutional?
Because it
could separate ever be equal?
No.
Why not?
Because going back to like the mental impression that separating something.
Okay, good. Yeah, that's what I'm looking for. Yeah, more on that, please.
It just creates like an inherent bias that like, okay, well, if I'm separate, like, why do I have to be separate? Because I'm better or because I'm worse? It's the effect that it has.
Okay, very good. Thank you, Lauren. I think that's more or less what I was going for. The court could have just said, you know what, the funding in these Kansas schools is not equal to the funding in the white schools. Therefore, the state of Kansas must increase funding to the Black elementary schools. That would have been a very unsatisfying ruling for the plaintiff, for the Brown family. And I keep saying the Brown family because I think there were two Brown daughters. One of them, by the time this case was resolved, she'd actually moved on to the next level. She wasn't even eligible to go, but the younger Brown daughter was still eligible to go. So there were two Brown daughters in this case. What the court says is segregation of Black and white students in public schools has a detrimental effect on the Black students. It creates this sense of racial inferiority. And there's this footnote, very famous footnote, not quite footnote 4, but footnote 11, very, very famous. Footnote 11 has all these social studies sciences, which have not really held up. They're not well viewed today. They're not very accurate. They were not well conducted for the time, but put that aside for a minute, right? The studies generally showed that when you have students in segregated schools, they come to view their own race as unequal. So, for example, one of the studies, a very famous test called the doll study, asked children to pick which doll they prefer. There was a black doll and a white doll. And they found that the students in the segregated schools were less likely to pick a black doll. They had an inferior sense of their own self-worth. And the court says that this segregation creates this inherent bias. And the 14th Amendment cannot tolerate this sort of segregation. And at the end, they say that the holding in Plessy is overruled to the extent it's consistent with this sort of analysis. Plessy is not overruled entirely, because if it was, that would mean public accommodations, trains, all the other facilities would be integrated. So the holding here was really limited to K through 12 schools. It could be extended later, and it certainly was, but the holding itself was very strikingly narrow. And then you get to the end, it says, well, the school segregation laws in Kansas, South Carolina, Virginia, and Delaware are unconstitutional. And then it sort of just ends. Okay. We'll get to the other Bolling in a minute and Brown too in a minute, but any questions in the Brown decision itself? No? All right. There were several cases going on at the same time. We discussed the cases from Kansas, South Carolina, Virginia, and Delaware. These are the state cases. There was also what's called a companion case from D.C. And D.C. schools were also segregated to this day, to 1954. The D.C. case presented a bit of a problem for the court. The court just found that the 14th Amendment Equal Protection Clause prohibits segregated schools. Okay, that was the holding. But the 14th Amendment only limits states' power. The 14th Amendment doesn't limit federal power. And if you remember in Korematsu, which was decided in the 1940s, the court basically said the Equal Protection Clause doesn't control the federal government. What provision does? The Due Process Clause. So here the court got a little bit, shall we say, creative. The court recognized that there was no text in the 14th Amendment that limited the federal government. So they said, we have an idea. Let's, how do I put this to make sense? Let's pretend that the Due Process Clause, the Fifth Amendment, actually has an equal protection component, right? It's as if you took the Equal Protection Clause of the 14th Amendment and you brought it back to the Fifth Amendment. This process is known among law professors, at least, as reverse incorporation. Reverse incorporation. It doesn't make a terrible lot of sense until you realize that the court couldn't say, okay, fine, Kansas, your schools have to shut down, but DC, yes, you can keep your segregated school up. This is, I think, what Ash said before. There has to be a right answer here. And the right answer is not going to be Kansas, yes, DC, no. Right? That wasn't going to be the answer. There was no way the court was going to allow that to happen. It wasn't. So they made up a ruling that, frankly, you can defend it, and I'll show you how to do it in a minute, but it's a ruling that on its face doesn't read well. Like, you have this long discussion of the Equal Protection Clause. Now, let me take a step back. If all along segregated schools violated the 14th Amendment's Due Process Clause, why did you need Brown altogether? Why couldn't you just say that the segregated schools violate the Due Process Clause of the 14th Amendment, right? Why couldn't you have the same rationale for both federal schools and state schools? Why do you even need the 14th Amendment Equal Protection Clause? The short answer is they wanted to get rid of Plessy, right? And Plessy was a ruling on the Equal Protection Clause, and that's why they did it. But if the Due Process Clause was a valid basis in one case, it should be a valid basis in another case. All right, now one more wrinkle for you all. Why was the court so hesitant to use the Due Process Clause? What's our favorite case? Lochner. We just spent more than 2 decades saying we were out of the business of using the Due Process Clause to stop state laws. Now you might say, well, what about footnote 4 and the discrete and insular minorities, right? Isn't that sort of the carve out? Yeah, perhaps, but for many years the court had upheld segregation in light of footnote 4, right? They never even hinted in those other cases that footnote 4 meant segregation laws were unconstitutional, right? There were lots of cases the court turned away. So they were still afraid of Lochner. They didn't want to upset footnote 4. So they relied on equal protection primarily, but then they sort of just wiggled this little sleight of hand with reverse incorporation on Bolling v. Sharpe. If a judicial nominee is asked by Brown, they can give a good answer. Bolling is tougher. I think you can do it. Randy does it better than I can, but I think you can do it. But the argument is basically this. Public education in the form of liberty. And denying people this liberty on the basis of race is arbitrary. I think if Buchanan v. Worley, right, you can't restrict people selling property on the basis of race. So you can't also restrict the provision of this liberty. Now, I don't know that Randy's right. I'm not sure that public education is liberty. I think if it is, that means a lot of other things have to change. But you can make this argument. I think it works. Eleni, go ahead.
Can education be argued as property? And not the process of education, but actually the education that I end up with because of it?
Do you remember a case in property where I don't know if you did this case where it was a marital property case where there was a husband and wife, and the husband was going to grad school and the wife was working to put him through school. And the question is whether the diploma could be a property interest.
I think that's where my question's coming from.
And the court held that it's not, that you can't treat an education as a property value. So I think the short answer is no. I don't think education is property in the traditional sense of the word. This is where I slightly disagree with Randy, not entirely, but generally the concept of liberty means the absence of government, right? The government's leaving you alone, right? You have these pre-existing rights, but when the government gives you public education, it's a privilege, right? Which they can take away. What I'm saying here is not universal, but there's no God-given right to public education. Now, some state constitutions do provide a right to education, and there's been litigation over states that fail to provide that minimum level, whether complying with the Constitution. But the federal Constitution, I don't think, provides a right to education. Although, again, Randy disagrees, and I think that has very important implications for the Brown and the Bolling case. Because if Randy's correct, then Brown and Bolling are much easier cases, because education is so fundamental. There's actually thinking that education might be a privilege or immunity of citizenship, right? That's what Michael McConnell thinks, which he's referenced in the readings. If education is a privilege of citizenship, then you can rely on the Privileges and Immunities Clause. Again, I'm not convinced of that entirely, but I'm open to it. It's a worthwhile theory. Does that answer your question, Lainey?
Yes, thank you.
Good, my pleasure. Right, so I think if you accept the notion that education is a privilege of citizenship, then these cases get easier. But if you don't, these are both hard cases to reconcile. Brown and Bolling, they just sort of in tension with each other. Yeah, Bolling, every time I read it, just feels like an afterthought. It's like, well, we can't possibly think the schools in DC are different. And just amazing, I'll get to you in a second. It's not insane to think that was actually the rule, right? I don't know why it has to be the case that the states and the feds are in the same standard. Keep in mind, during Reconstruction, the fear was the southern states. Congress wasn't worried about itself, right? Congress didn't impose itself to that requirement because they weren't worried about itself. Macy, go ahead.
So this case really feels like one of those situations where the court knows that they have to make the decision, so they're just kind of grasping at straws to justify it. Is that a good understanding of what's going on here?
I'll slightly disagree. I think if Chief Justice Warren was okay with a 5-4 opinion, he could have written a much better decision. But he was so intent on getting this 9-0 that, look, we can all be honest and say this is the right outcome, but this was not the best decision to write. There was a book published about 10 or 15 years ago called What Brown Should Have Said, where a bunch of law professors basically rewrote the Brown majority opinion. They wrote a concurrence or dissent based on information available at the time, right? In other words, knowing what we knew, I'm sorry, I said it wrong, knowing what was known in 1954, how could you have written a majority opinion? And it's a good read, right, of how you could have written a Brown opinion. There's the same book for Roe v. Wade should have said in 1973. And now there's what a Bergeville v. Hodges should have said in 2015, right, the gay marriage case. If you notice, this is not a knock on the cases, but the most significant Supreme Court cases of the 20th century, Brown, Roe, and Bergeville, are not models of legal clarity. They're not. And you can agree with the outcome, but just they're not. And they're subject to extreme criticism because the reasoning is so thin, right? They reach results people like with reasoning that is hard to defend on its own. So you have law professors who say, oh, here's what they should have said, right? They should have written this and this and this, and that's where we are. Okay, that answer your question, Macy? All right. I think I'm just about done with Brown and Bolling, or at least Brown 1 at least. Any questions on Brown 1? All right. So now we get to the end of Brown and Bolling, but they're together. It's not thin reasoning, it's non-legal reasoning, Okay, I'll accept that. I'll accept that friendly amendment. That's fair. Okay, so we get to the end of Brown 1, right? And the court has to decide to remedy. And this is very important. Usually when you get to Supreme Court decision, you don't think about the remedy. It's like, okay, all right, Lochner, Bake Shop Act is unconstitutional, that's it. Or, the minimum wage law is unconstitutional, that's it. Or the detention program is valid, that's it, right? But here the remedy proves to be very difficult. Because the justices recognize full well that this decision was not going to be accepted lightly. That people are not going to say, you know what? Shucks, we were wrong. You know what? Let's open up the schools tomorrow. That was not going to happen. So instead of trying to issue some sort of a ruling, they said, all right, come back next year. Right? Come back next year and let's try this all over again. So, there were headlines. There's a very famous, iconic photograph of a mom with her daughter sitting on the steps of the Supreme Court, and they're having a newspaper. It says, the school segregation ends. And it's not exactly. Not exactly. Then we have Brown number 2. Brown 2, it's called. Where they ask all the parties, what should we do about the remedy? And at the end, the court basically says, we're going to wait and see. Right? We're going to wait and see. The lower court should move with, quote, all deliberate speed. That's the phrase they use, all deliberate speed. And the lower courts will retain jurisdiction, which means what? Not our problem, right? Lower courts, you figure this crap out. You deal with this nonsense. We don't want to deal with this. Come back to us if it's bad, but this is not going to be our show. And with that, the Supreme Court basically deputized federal court judges across the country to ensure that the schools are integrated with all deliberate speed. This process would not work very well. Not well at all. At all. It was really bad. Our next case, Cooper v. Aaron, illustrates how bad this got. All right. I hope if you watch any video this semester, watch the one for Cooper. I think it's our best one in the entire library. I'm very proud of it. We have a lot of archival footage, which I don't have time to show you here, but I encourage you to watch it after class. We're sure already watched it, right? If you haven't, definitely watch that one. Okay, so let's talk about Cooper for a minute. Brown only involved 3 states, 3 or 4, depending on your count, right? Kansas, South Carolina, and Virginia. Its decree in Brown 2 bound those cases. Now, we've talked before about Mr. Lincoln and Dred Scott. And Mr. Lincoln argued that, well, Dred Scott was a conflict between Dred Scott and Sanford and not anyone else. Therefore, the federal government was not bound by the decision in Dred Scott. And you're like, yay, go Lincoln, right? Give a middle finger up to Taney, right? Yeah, guess who followed Lincoln's playbook? The southern states. And throughout the South, the southern governments basically said, you know what, we are not going to follow Brown voluntarily. If you want us to integrate our schools, you have to sue us, one at a time. And the situation in Little Rock became violent. So here was the conflict. A federal judge in Little Rock argued that the schools had to integrate. Then a state judge, excuse me, late night. Then a state judge argued, no, the integration violated the state constitution. So you have this conflict. Okay. Then the federal judge issued an injunction to block the state judge. Then things got ugly. The governor, his name was Orville Faubus, ordered the Arkansas National Guard to block students, black students, from entering Central High School. If you ever go to Little Rock, you can actually visit the high school. It's a public museum, but it's also an active high school. There's still students studying there. And it's about a couple miles from the state capitol. It's very close to the capitol. So this was a very close to home issue. Now, was Faubus ignoring the Supreme Court? Not really, no. He was not bound by an injunction. So what happened next is that the federal court issued an injunction against the governor. So what happened? The Little Rock Police Department shows up. Because the Little Rock Police Department were not bound by the order. See, this is like a game like whack-a-mole, right? Where you have an injunction against one party and another party shows up. And throughout all of this conflict, the school was denying entry to these 9 black students who were very brave. If you watch the videos, it's just stunning how brave they were. I don't think I would have enough fortitude to do what they did, to walk through, these people yelling and jeering at you, and it's remarkable. Then the situation escalated even worse. President Eisenhower, by the way, Eisenhower did not agree with Brown. He never defended the decision. He didn't criticize it, but he never defended it. He thought the court was out of line, that the court should not have been intervening in local matters. It's true. He was not happy with Earl Warren for this at all. This is a well-known historical fact. But Eisenhower did not like states ignoring federal judges, the federal district court judge. So when Eisenhower announced that he was going to send in federal troops, he did not even mention the Supreme Court, did not mention Brown. He says they're ignoring the lower court orders. So he sort of reoriented his focus. But Eisenhower sent in the 101st Airborne to Little Rock. And these were the paratroopers who basically fought across Europe. These are, these were serious people. This is not a joke. This is like the first time since Reconstruction that federal troops were sent to the South. This was a big deal. They were deployed to Little Rock, and their mission was to escort the 9 kids into the public high school, into Little Rock High School. And just pause to think for a second. What would have happened if Eisenhower didn't do this? He said, you know what? I think Brown was wrong, and all right, so what? Had Eisenhower not acted, the school desegregation movement would have basically ground to a halt. Once one jurisdiction was able to ignore the court orders, it was spread like wildfire throughout the entire South. So had Eisenhower not acted, Brown would have been a dead letter. I mean, you can maybe disagree with me, but I think if Eisenhower didn't step in when he did, the court's ruling would just be paper, parchment barriers. It would not have had any effect. So this was a very serious, significant decision of the court. Of the governor. The president to put the troops in. Right? Hamilton wrote, the courts don't have the power of the sword. Yeah, they sure as hell don't have the power of the sword. And they can't enforce their own judgments. So Eisenhower did what he did. Then things got even more. Stuart, are you serious? Please.
Yeah.
You want to speak up?
No, I just remember she told me this as a kid, that she was in class that day, and that the army came and they were escorting these troops in, and they were all watching from the window. So it's weird, like studying it in depth now. Everything that a kid, my grandma.
She went to Central High School?
Mm-hmm. Yeah.
Wow.
Yeah. She was in class when all this was going on.
Does she remember anything else about it?
She told me as a kid. I don't know. I probably forgot the details, but I'm definitely gonna ask her again next year.
She would have been in high school, so maybe she was 15, 16 years old. Do you remember?
Probably 15.
Wow. Well, yeah, ask her about it. If she has anything else to add, you can report back next class. I have a slightly not as good story. So throughout the South, a number of schools were opened up for white students only called the Citizen Council Schools. And a couple of years ago, I had one student who raised her hand and said, "Oh yeah, my mom went to a council school." I'm like, "She did?" "Yeah, she went to a council school." I was like, "Do you know what that means?" She's like, "No." So the mom had no idea. It was basically a segregated kindergarten run by basically the Klansmen, right? The mom had no idea what even it was. She had just, she's a little girl. She had no idea. But she basically went to a white supremacist kindergarten, and she got all embarrassed. It wasn't her fault. Like, I didn't want to beat on her, but like she just had no idea what that even meant. I'm like, I'm going to tell you what that means. It's not a good thing. I think she was in Mississippi, I think, if memory serves. But anyway, well, Stuart, if you can find anything else, please bring it back to us. After Eisenhower sent the troops in, just watch the video. It's in there. It was just chaos, right? People were cursing and screaming at these 9 students and just directing so much hate at them at every moment. And the students basically had to sit in the principal's office all day because they didn't want to get beat up in the hallway. It wasn't going to work, and a federal judge said, "We can't have this much chaos." So he issued a ruling to postpone integration by 30 months. This was a judge, again, who ruled earlier there had to be integration right away. But the judge on the ground said, this is not going to work. You can't have education with federal troops walking around the building. Then the Court of Appeals reversed and said, no, you have to integrate right away. This, I think, was in August, so the school would open up the following September, a month later. So then the case went to the Supreme Court on an emergency appeal, and it was argued before the term even started. They had a special term to hear it. And after everything, the court ruled that the extension was unconstitutional. It was not consistent with Brown. The 30-month extension was not with all deliberate speed. And that part is probably right. You talk about deferring to the state courts on the ground, but when they grant an extension, they get reversed. The court kept going, though. The court seemed to suggest that the decisions of the Supreme Court are the supreme law of the land, and that the governor is bound by the Supreme Court's decisions, even if he's not a party to this case. This was a bold statement, which is almost certainly incorrect as a matter of constitutional law, but they said it. As a result, Arkansas governor was bound by this. Did Cooper v. Aaron result in the opening of Central High School? The short answer is no. And Stuart, your grandmother may have some knowledge of this history. What happened in Little Rock was kind of a scam. The school basically transferred ownership of the high school to a private company, which was not bound by the 14th Amendment. And once it was transferred to this private company, they said, okay, no black students are allowed. And this went for years. Other schools in Arkansas simply shut down. Right? They simply shut down. So you have entire generations of schools that have no graduates. There's no class of 1959. There's just no class. They didn't graduate anyone. Other schools basically started providing people with vouchers to fund segregation of schools. So you would basically get a tax credit to go to a private, for example, the council schools, which were set by the supremacists. It would take almost a decade, 10 years, to fully integrate Little Rock high schools. 10 years. So, I mean, the Brown decision was momentous in 1954 But we're not talking until the mid to late 60s before the school actually integrated. Even after Eisenhower sent in the troops. That was sort of like the crisis moment. And after that, it just fizzled along. Really important case, Cooper v. Aaron. I think it's probably, Justice Barrett, during a hearing a few weeks ago, was asked by Brown, and was it Senator Whitehouse, or I think it was Senator Whitehouse, who asked about, with Brown, doesn't Brown? Oh, I remember what the question was. The question was, are people required to follow the courts? Right. In other words, I think he asked, was the president required to follow a court judgment? And Barrett said, well, the court can issue its ruling, and then it's up to the president to decide whether to comply. And, Whitehouse says, well, how can you say that, right? You have a decision like Brown, doesn't everyone have to follow it? And then Barrett's like, Cooper. And she had the cojones to actually say Cooper. Usually they're afraid to say it. But Cooper is proof positive that the Supreme Court decisions are not, gospel, that they're not always treated as divine word, and that there is sometimes resistance to the court's decisions. Yeah, very. James saying in the 1970s schools weren't integrated. He's right. There are still some districts in the United States to this day, 2020, to this day, that are under federal supervision by courts about integration. To this day, in 2020. It's true. This is not. It didn't end in the 50s, it didn't end in the 60s or the 70s or even today. It's still ongoing. It's remarkable. It's sad. Very sad. All right. I'm going to have to rush Loving, aren't I? If I need to spill over, I'll spill over. I'm sorry. But I want to make sure we give Loving its due. All right. Any other questions on Cooper? Anything on Cooper?
Can I ask a question?
Please, of course.
So the holding of the Supreme Court is the supreme law of the land. So it binds everyone.
That's the holding.
We're not supposed to.
I'm sorry, the last thing you said?
We're not supposed to write that down as like good law?
Oh, no, that's what the Supreme Court said. That's the law. I mean, you realize it's kind of circular, right? The Supreme Court says that its decisions are the supreme law of the land, and for its authority, it cites the Supreme Court decision. So it's completely circular, right? They said, our decisions are the supreme law of the land, and therefore it's so. Like, Moses at Sinai with the tablets for the cloud, right? Just right there.
I thought they cited the supremacy clause.
Let's look at the supremacy clause. Right? The supremacy clause says, I'll paste into the chat so it's screen sharing, right? I'll paste it right here. Okay. It says, this Constitution and the laws of the United States, which were made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything the Constitution laws to the contrary. Where does it say that the Supreme Court's decisions are the supreme law of the land?
Well, if the Supreme Court is interpreting what the Constitution is saying, isn't that the Constitution?
Says who?
That's literally what I thought they were saying in this holding.
Well, that's what they say in the holding, but does that follow from the text of the Constitution?
I guess not.
I don't know. You tell me. I'm looking at the supremacy clause. It doesn't say the Supreme Court's decisions are the supreme law of the land. I know the court said it. You're right. You're describing the court's holding accurately, Laura. I think you're exactly correct. But where did the court get this from? It's not from Marbury. It's not from the supremacy clause. They just asserted this power. Right? Cooper's where this power was asserted.
So then we should know. So that's why you brought up like ACB, and so she was saying no.
ACB is Amy Coney Barrett. If you're not hip enough, yeah. But Amy Coney Barrett, yeah.
So we should know that like people aren't actually bound by Supreme Court decisions.
No, I think Cooper says what it said, and that's the rule. It's not accurate though. It doesn't describe how things work. I'm sorry?
I think I'm not following when you say like accurate. Do you mean like accurate in the Constitution or accurate like as in good law?
how do I put this? The Supreme Court made a statement, and they started this as the rule, but no one actually takes it seriously, right? And I'll give you an example to prove this point. When the Supreme Court declares a law unconstitutional in one city, right? Let's say the exact same law exists in another city. Does that law fall off the books? Does it magically disappear?
Yeah, I thought the Supreme Court bound
Oh, they like to think they do, but that's not how it works. In other words, the statement made in Cooper, and I wrote a very long article on this, I don't want to bore you with it, but the statement made in Cooper was just made. They've never once cited it since and never come back to it. It was sort of this last gasp in the civil rights case. Civil rights movement was like, here, we have all this power, and they said, never mind, we're not going to assert it. So they said it, but it doesn't really have any weight.
So then how, when the federal government does things, like the Supreme Court does things like legalize gay marriage, every state has to follow that.
Wrong.
Is that not this?
So that's absolutely wrong. They didn't. So the case of Bergethal v. Hodges is a very good question, Laura. The case of Bergethal v. Hodges involved marriage laws from Ohio, Tennessee, Michigan, and Kentucky, 4 states. At the time, Texas had a gay marriage law, right? When the Supreme Court ruled, did the Texas law magically vanish? No. The Fifth Circuit had to come along and say, okay, in light of Bergethal, we're going to put the Texas law on hold. There needs to be a subsequent decision to stop the Texas law. It's a myth. I'm sorry. I wrote an article called "The Irrepressible Myth of Cooper v. Aaron." That's why I'm a little of a hobby horse right now. But after the gay marriage decision, was decided, the Texas marriage law didn't suddenly disappear. It didn't suddenly vanish, right? You needed another decision, the Fifth Circuit, to actually halt the Texas marriage law, which is proof that Cooper can't possibly mean what it says. It can't possibly mean what it says it means. They said it, but it's not real. And that's a very unsatisfying statement. You seem very perplexed.
So what you're saying is states didn't really have a choice, because if their laws were in conflict with, they still had, anti-gay marriage laws on the books. They had to, within their own state, overturn them, or they would be in violation.
Correct. A subsequent court overturns it. The Supreme Court doesn't immediately overrule every law nationwide. It requires a subsequent legal action to declare it unconstitutional.
Okay.
You can have, you know what? I think we have to do Loving next week. I can't do justice to that case in 5 minutes. No. Is Loving in the calendar for today or next week? I thought I moved it. Oh, no, Loving's next class. Okay, good. I'm sorry. Thank you, Macy. I always teach Loving after Cooper. I'm like, no, that's not right. I moved Loving. Oh, we're good, my friends. This is wonderful. I'm looking at my notes and I'm like, no, I'm not doing Loving today. I had a mental lapse. I'm sorry. Okay, good. So let's spend more time on this. So let me explain this a little bit more clearly now that I know I have more time for it. Thank you, Macy. Appreciate the update. I told you I rejiggered my syllabus because of the shorter time schedules, and this is... Oh, God. I'm sorry, James. I'm sorry. I'm making you guys panic. I'm sorry. So let me try this again. Laura, let's try this a different way. You guys learned in civil procedure the concept of estoppel, right? If I sue you, right, and I have a judgment against you, you can't ignore that judgment, right? You and I are in a lawsuit, and I have a judgment against you, and you exhaust all your appeals, you lose, that's a binding judgment against you. Is Macy bound by that judgment?
No.
No, why not?
Because she wasn't a party.
Yeah, she wasn't served process right. She wasn't given notice. All these things you have to do. That's always the case. When the Supreme Court decides a case between Party A and Party B, or Cardi A and Cardi B, perhaps, I don't know, right? The only people who are... Sorry, I couldn't help it. The only people who are bound are those who are in front of the case. right? Now, people could choose to follow a Supreme Court precedent, right? If the Supreme Court rules that a gay marriage law is unconstitutional, is Cardi B a dad joke? I think that's pushing it, right? If the Supreme Court rules that a gay marriage law is unconstitutional, a responsible civil servant will say, you know what, I'm not going to enforce that law. But someone might say, you know what, screw the Supreme Court. I'm not going to follow them. They have to get sued again. And another lawsuit declares the gay marriage law in Texas unconstitutional. In other words, the Supreme Court can't universally strike down every law everywhere. They can't. They don't do that. That's not how courts function. That's not how courts operate. Not the Supreme Court or any other court. So what I'm trying to get at here is that the Cooper decision asserted this very broad power that the court didn't have. It's a court they've never since exercised and never even referenced this power.
Professor, you were frozen, so we didn't catch the last thing you said.
I know. The Comcast truck is outside. I'm just dreading it. I just see them. They're just awful.
It's stalking you.
No, I know. They came by yesterday. I was dying because I had all my TV stuff. Right. The short answer is the Supreme Court asserted a power that they don't have. And they've never come back to it since Cooper. Okay? Just got my Cardi B joke. All right. Laura, is that clearer?
Yeah, thank you. Sorry I took up so much time.
No, you no need to apologize. I think you asked an excellent question. And that's why Justice Barrett's response, because look, most of the nominees are okay with just BSing and say, oh, of course, Kavanaugh. Kavanaugh said Brown was the court's biggest moment because it was unanimous in this awesome decision. Well, yeah, that's nice, Brett, but everyone ignored it, right? Everyone ignored the case. And they ignore what comes after Brown. And I think it's important to talk about how people had this decision to also mention that, look, there were a lot of white supremacists who just ignored it. LOL, Brett. Yeah, he and I are besties. At least we used to be. People ignored the decision. And they had the so-called massive resistance to massively resist the Brown decision. And it took, 20, 30, 40, 50, half a century to even get close to what the court was trying to get at. So what I'm trying to say is, when the Supreme Court says something, it doesn't make it so. I know this is a hard lesson for people, right? Hearts and minds don't change overnight, right? Right? People believe what they believe, and a Supreme Court decision might be a useful way to draw attention to the issue, but there are limits. There are limits of how far the judicial decision goes. Yeah, Denver, go ahead.
What about something like Montgomery v. Louisiana, where they had to go back and apply the Miller decision retroactively?
Montgomery, now you're stumping me. Was that a juvenile life without parole?
Yeah, juvenile.
Yeah, I mean, look, I don't want to minimize Montgomery, but there's a long-standing controversy whether minors can be sentenced to life without parole. I don't think you can put that in the same sentence as Brown. I mean, it's an important issue, but it's not like something that national. I'm talking about segregation, maybe decisions on abortion, maybe decisions on gay rights, right? There's certain decisions that let me try this another way. Justice Ginsburg, blessed memory, was a critic of Roe. Huh? Truth. She criticized Roe as saying the court went too far and too fast. That she says in 1973 the country was not ready yet for such a broad ruling on abortion, and in many regards, Roe yielded a backlash similar to the backlash after this the Brown decision, where states started to basically try to enact even stricter laws about abortion. And Ginsburg said that if the court had not issued such a broad ruling on abortion, this issue would have been less divisive. Now, I'm not saying the same thing would have happened with segregation. It's kind of like a counterfactual, right? But if Ginsburg is right, if the court steps too far ahead of the mainstream where people are, it may actually slow or impede social progress in that regard, right? If the court goes too far ahead, which is why usually the court is sort of like if you think of like on a train, is the court the locomotive pulling it, or is the court the caboose, sort of just dragging along in the end? And usually the court's the caboose. Roe, I think they were the locomotive. Brown, not really sure, maybe in the middle, but they weren't the caboose in that one. They were sort of maybe in the middle of the train car. Other questions? Very, very good discussion. Yeah, I'm actually glad I moved Loving to the next case. I'm sorry. I freaked you all out. Oh, my internet's about to die again. Comcast, I hate you. Okay, I get this warning to unstable internet. We're almost done. All right, questions? All right, let me try to summarize as best as I can the school desegregation cases. We have Brown, we have Bolling, and we have Loving. Brown, Bolling, and Cooper, sorry. The Brown decision didn't really establish a standard of constitutional law. It didn't say that racial classifications are subject to strict scrutiny. It did not say that education is a fundamental right. It did not say that education is a privilege or meaning of citizenship, right? It didn't try to fit its ruling into any sort of constitutional test that we are aware of, right? It sort of was a one-off. They said, well, you know what? Education is very important. It's an aspect of citizenship. Separate is inherently unequal, and it creates unequal education, so we can't have it. But it didn't lay a foundation of how this ruling could affect other cases. So imagine the court had said that we think that all racial classifications are suspicious, and we're going to review racial classifications with rigid, strict scrutiny. They could have done that. But had they done that, they would have cast in doubt a lot of other laws, and they weren't ready to do that yet. When you read Loving for next class, not today, next class, you'll see that the court says that a ban on interracial marriage does trigger strict scrutiny, that racial classifications are suspicious. But they couldn't get there in 54. They got there in late 60s. The second case, Bolling against Sharpe, was also somewhat, how someone says, non-legal reasoning, right? It argued that the Equal Protection Clause of the 14th Amendment actually applies to the Due Process Clause. So now the federal government and the state governments are bound by the same standard. And then we get to the third case, Cooper against Aaron, which is a really significant case, which seems to suggest that the court's holdings are self-evident. They are the supreme law of the land, and everyone must follow them. Which looks really awesome on paper until you see what happened in the aftermath, where these schools are shut down and they refuse to integrate, and it took decades to open up. So I think I respect Justice Barrett's views in this one. The Brown-Cooper line of cases is sort of a mixed bag for the Supreme Court's reputation. Brown is sort of this shining moment of unanimity, and then only a few years later you get to Cooper. It's like, oh crap, now what? We don't have the power of the sword. Mr. President, please help us. And after that, the president didn't help much more, and there were not more troops sent into federal schools after the 1950s. And at that point, it was up to Congress to use funding to integrate schools. If you don't integrate schools, you don't get funding. And money speaks, money talks. And that's really what opened the schools up. Eventually, hearts and minds changed. People modified their views. They said, okay, this is insane. We can't keep this up forever. And the courts played an important role, but I think it was really the executive and the legislative branch that really pushed forward across the finish line. All right, questions. All right, I'll start the minute poll, which you can please put your quiz question today, so it's for class. Please put your minute poll in. I'll be back around 12:30 for office hours, and if not, I will see you on Saturday or Sunday. Anything else? Okay, Comcast didn't stop me. Good. All right, everyone, take care. Bye-bye. Mm-hmm.